Yeah, welcome.
Okay, thank you. So, dear colleagues, it's so nice to see you today. And on behalf of Ukrainian Association of International Law, it's a pleasure for me to greet you here. We continue our online briefings of the Ukrainian Association of International Law. And it is a pleasure for me to greet here our guests, our estimated scientists in the field of international law and in particular in the history of international law, Professor William Butler from Pennsylvania University, Professor Anthony Carty from Beijing Technological Institute. And so nice to meet you and welcome, and thank you for your participation here. Today we continue briefings of the Ukrainian Association of International Law, and please correct me if I'm wrong, but I think that today we will touch the most theoretical issue of international law, because before that we have discussed during our meetings, during our briefings, we have discussed actually more practical problems of international law, problems of international humanitarian law, international maritime law, sea law, international air law, and jurisdiction of states, and international private law, and all different practical issues. But today, maybe that for the first time for this for the whole year of our briefings, that is maybe for the first time when we are going to discuss more theoretical issue, the history of international law, the problems, existing problems, approaches to the history of international law. At the same time, in my brief report, I would like to say that the history of international law should not be regarded as purely theoretical issue. It should be regarded as more practical ends, and it should be regarded as a means of understanding practical application of international law and the practice of present day international law. But for this, we should change somehow our approach to the history of international law. So the first thing which I would like to say here, that probably each institution, each essential element of international law has its own theory and has its own methodological apparatus. Today, if we will take, for example, on territorial aspects, responsibility, subject of international law, sources of international law, etc., they have their theory, and the teaching of these institutions is based on the proper theoretical and methodological basis. We can say the same about the history of international law, which for a rather long time was underdeveloped as a science. The history of international law as a branch of its theory, as a part of its theory, as a part of international legal science, has relatively late origin. International lawyers have been actively trying to study the history of international law practically since the middle of the 19th century. And there are several causes for that, several reasons for that. First, that was a classical period of the European science of international law. The late 18th and the middle of 19th centuries, that was the period of formation of international law as a science. That was the period of active development of the European science of international law. During that period, international law became certified university discipline. It was taught in academic institutions. Therefore, all that led to some Eurocentricity in approaches to the history of international law. Second problem of that time, that was a period of active discussions about the legal force and effectiveness of the law of nations. That was actually a period of struggle between apologists and deniers, objectors of international law. Given that international law itself has not been recognized as a separate discipline for a long time, works on theory of this law in the middle of 19th century mostly contained explanation what international law is, why it is effective, why does it have any legal effect, is it actual discipline, and so on. On the one hand, proponents of international law, international lawyers, during their discussions, they sought to show that the law of nations is a full-fledged legal discipline, is a full-fledged science, and as such, it has its own history. Also, they used very actively, they used an argument of the concept ubi societas ibi jus. But on the other hand, apologists for international law proved its legal force and effectiveness, and like their opponents, they focused mainly on the analysis of practical aspects of regulation or of international relations contemporary to them. Therefore, they have developed a methodology aimed at arguing the legal force of international law and its effectiveness. And for many of them, history of this law has been left outside as too theoretical. Third thing about that period, that was a period of positivism in international law and legal science. Positivism considered mostly existing law, so its representatives at that time and even later, they very infrequently turned to legal history and to international legal history. In addition, positivism makes clear requirements for the elements of legal system, for the legal system. This system should be mostly written, it should have positive legal act as its source, and it should have state as its main subject. Guided by these theses, it was not always possible to study properly international law of these or that periods and international law of these or that regions of the world where and when treaty was lacked and there were no states as subjects of this law, as actors of international relations. Since the end of 20th century, interest in international legal history is reviving, and it is evidenced now by plenty publications on this subject. However, such a relatively late emergence of international history of international law, and general recognition of the history of international law as the field of its science, practically only starting from the 20th century or even the middle of the 20th century. All that led to the lack of proper research method and scientific style of research even today. There are problems with terminology, with research methodology of international legal sources, international legal use, the history of international legal thought, etc. One of the most important problems of this science is the absence of separate scientific fields, such as international legal historiography, history of international legal sources, history of international legal thought. Due to the lack of proper methodology, scholars had to use methods and principles of research borrowed from other areas, from the history of international relations, from the history of diplomacy, from the history of state and law, and from the general history of mankind. Also, there are some objective reasons for such a situation. The findings of the most valuable diplomatic archives, for instance, I'm speaking now about the history of ancient world. So the findings of the most valuable diplomatic archives of the ancient world date back only to the end of 19th century and the beginning of 20th century. For example, the Tell el-Amarna archive of diplomatic correspondence of the Egyptian pharaohs that contained more than 500 documents of international legal practice of the second millennium BC, and all that was found. All that was founded only during 1887, 1890s. The Archive of International Treaties of the Hittite Kingdom was, which contained also a valuable material on ancient international treaties. It was founded in 1929. Only in 1933, from 1933 to 1939, the archive of the city of Mari in Asia Minor was, with texts of diplomatic correspondence and international treaties was found. So all that led to the very late discovery of such sources. But besides these chronological problems and problems of this late discovery, introduction of such documents to the science was carried out not by international lawyers, but by historians, by archaeologists, by those who did not treat these documents as internationally as such that have international legal value. In general, there are several methodological approaches to the study of the history of international law. The first is the general historical methodology. It was the first used by international lawyers to study the history of this law. It was based on general historical criteria, and here scholars made some significant contributions to the study of text of ancient, medieval, and even classical international legal sources. But at the same time, the use of this method did not allow to go beyond textual analysis and to take into account the purely legal nature of these texts and of these sources. The next method which was used, that was a purely legal method of studying the history of international law. And here we also see some problems in using this method. According to it, the history of international law was studied from the ethatist point of view. At the same time, during a long period of history, there were no states as such. In the classical sense, the state is a product of European Middle Ages, or even the very end of Middle Ages. Actually, states in our classical and traditional interpretation, understanding, 16th century. Hence, we have two methodologically incorrect approaches. First, the history of international law, according to ethatist approach, the history of international law before the emergence of states, before the appearance of states, was denied at all. Or the second mistake which that we have today, in those periods and in those regions where there were no states, other social entities were called states in order to say that international law existed there. So in this approach, we have the situation when, for example, chiefdoms, tribes, cities, unions of tribes were called states and were regarded, treated as states, and actually intertribal, interchiefdom relations were treated as interstate relations. Another method which should be used, that is the method of comparative legal study. The method of comparative legal study is fully recognized in general theory of law, in different fields of municipal law, and even in international private law. But as a method of research, comparative law was rarely used in history of international, in the domain of history of international law. And here I should refer to a collection of papers edited by Professor Butler in 1980, I suppose, and that was on interdisciplinary approach to international law, and even at that time it was stated that a comparative method should be used. But it is, even today, it is almost lacking in studying the history of international law. As a method of research, comparative law would help us to establish the essence of different elements of international law. First, different regional subsystems could be compared. Second, historically established institutions, rules, or principles of international law could be compared. And third, features of international law in different historical periods also should be compared. The history of international law as a scientific field and as a part of its theory aims not only to describe past events. That's why I'm talking about history of international law as more practical discipline, and it should be revised as a practical discipline. So the history should be treated not only as a means to describe past events, but to identify the essence of international law. Scientists pose question when international law appeared. Instead of that, I would pose question why international law appeared and how it appeared. These questions and answer to these questions are more important in order to understand the essence of international law. One of the most difficult problems of the history of international law, which was touched by the lack of the proper methodology, is historical periodization of international law. Today we have different historical periodizations, but the first and the most popular, the most general periodization was periodization based on general historical criteria. Actually, periods of international law were compared with the proper periods of the history of mankind, of general history of the world. Besides that, some other criteria were also used here. These were conclusion of the most significant international legal treaties, international schools, and change of different scientific approaches. Some scholars combine different criteria for the periodization. But what is important to say here that the lack of proper methodology, which is the result of this such comparatively relatively late appearance of the history of international law. Due to this lack of methodology, scientists and historians also used this general historical approach to periodization of international law, or periodization of international law was based on some periods of diplomatic history, political history, etc. But here we should note that there could be no general common periodization of history of international law. Historical periods does not coincide, historical periods of international law and international law itself does not coincide in different regions of the world. For example, in order not to spare time, just one example, when Europe and European international law entered its medieval period, and when it could be called medieval international law, at that very time, international law of China and Chinese international law actually had this medieval form for a long time. So these periods are not coincided, and we can say about the unique, common, general periodization of international law. Very often in the science of international law, its history is understood only as a period of recent centuries and period of some recent developments and recent centuries. The lack of understanding that modern international law is the result of thousands years of evolution of its rules, principles, and institution. The lack of such understanding has led to underestimation of its ability to solve problems in international relations. For instance, there is continuity in international law, in development of international law, starting from the very intertribal relations and intertribal regulation till now, but there is no such continuity in any municipal legal system. So here we can say that there is an ability, there is an inner ability in international law to survive through different historical periods and historical transformations, and that is the peculiarity of this law. But that is maybe the problem of another topic, another theoretical topic. There can be no general chronologically identical history of international law for different regions and for different cultures of the world. Accordingly, the general historical criterion cannot fit the disclosure of the history of international law, which undergone its own stages of development in different regions of the world. International law is a very specific system which is characterized by uniformity and homogeneity for all peoples. This characteristic was noticed by Roman lawyers who defined this law as the law common to all peoples. And here the proposition is to treat international law not from the so-called linear chronological approach, from the approach of general history of humankind, general history of mankind, but from its own criterion. International law as a specific system is characterized by its own patterns of transformation and development. It is characterized by the dynamics of influence on international relations. The purpose of studying of its history should not only, and even to a lesser extent, to establish certain historical events. In general, the goal of the science of the history of international law should not be the history as such, but the clarification of the essence of this law and identification of its characteristics. The aim of international historians should be to find out how certain norms, institutions, or principles of this law reflect its characteristics. Each rule, principle, or institution reflects relevant historical features. It is possible to establish which norms of international law were characteristic, for example, only to the ancient period or medieval period, only to China or India, and which, having emerged with the very first regulations, survived to our time. The latter, these norms, which are characterized by such continuity, they form the framework of international law, which shows its essential characteristics. Almost every international legal rule or institution in its historical context contains information about the peculiarity of this law. Even if this rule or institution is characteristic to this or that period or to this or that region, it also shows, after it disappears, it also shows why international law abandoned this rule. And also that is about the essence of this law. The general chronological methodology does not reflect the specifics of this law and historical development of this law. Instead of that, we may propose the so-called institutional sectoral study of the history of international law. Given the comparative homogeneity of the emergence of international law in different regions of the world, we can compare the historical development of the institutions or rules of each of them. This approach can be called institutional sectoral. Each institution or principle of international law can be studied in its historical development from its very beginning, from its very appearance. And here we pose question why it appeared and how it appeared. Then we study the peculiarities of this rule or principle in different regions of the world and peculiarities of its historical transformations till today. So that is not the chronological linear study of different periods, starting from ancient, medieval, and classical periods of international law, but instead that is the study of each institution or rule of international law, or even some principle of international law. Sure, here we should also use this comparative study of such development in different regions and through different epochs. Besides that, for the full disclosure of the historical essence of an element of international law, such elements of international law, it is important to study such institutions, such elements, in terms of other sciences also. In addition to the actual comparative legal research, interdisciplinarity in a broad sense can be useful here. When studying the impact of the combination of these factors on the relevant international legal element, it is possible to fully identify its historical essence in the relevant period of history and the essence of law as it is, of international law as it is. To sum up, my idea is that any chosen methodology for studying the history of international law should aim to identify the essential characteristics of this law, including and mainly its present stage, its contemporary form, and its contemporary peculiarities. It should be directed not to the depth of historical events or facts, but to the depth and essence of the law itself. And it should show features, regulatory nature and purposes of international law. I think that such an institutional sectoral approach should be used in order to, as a new method of studying of the history of international law. So in order not to spare the time, I would I would end with that. I would finish with that, and maybe I will answer some questions.
Thank you. Thank you, Professor Butkevych. Dear colleagues, a few words about our work today. So today we have 3 keynote speeches. Olga Volodymyrovna has already presented the first one. Then we are going to have 2 more keynote speeches by Professor Butler and Professor Carty. And after these keynote speeches, we are going to have Q&A sections. So I invite you to type your questions to the chat of Zoom, and you will get answers to your questions. If you have a question to an exact speaker, please indicate his or her name. If you have a general question and you want to see some discussion about some topic, so you may just type your question or what you want to hear and what you want to be discussed. Now I think it's time to go to Professor William Elliott Butler, who is a prominent American comparative law educator and lawyer, who has specialized on the law and legal systems of Russia, Ukraine, Kazakhstan, and the other post-Soviet legal systems, Mongolia, the Chinese Soviet Republic, and an expert in the field of public and private international law. Now, Professor Butler is John Edward Fowler Distinguished Professor of Law and International Affairs at Pennsylvania State University. He has founded learned journals and yearbooks. I will name only one extremely close to our today topics. It is Jus Gentium Journal of International Legal History. Professor Butler is a friend of Ukraine. He is a foreign member of the National Academy of Sciences of Ukraine and the National Academy of Law Sciences of Ukraine. So now I give the floor to Professor Butler to present his report under the title Translation of International Legal Doctrinal Writing, Hugo Grotius and Friedrich Martens. Professor Butler, you are welcome.
I'm unmuted.
Yeah, we can hear you. Yeah, you are welcome.
Thank you. As it happens, my topic today complements what Dr. Butkevych has been talking about, but from a slightly different angle of vision. I chose to talk about legal translations because I have two books which are literally in press as we speak that deal with different aspects of this problem. One of them deals with the 7 English translations of Hugo Grotius on the law of war and peace. There have been 7 since 1654, ending in 1928. And they have been reprinted. Recently, the Liberty Fund in Indianapolis, which some of you know, reprinted the 1738 translation of Grotius, and the Law Book Exchange in New Jersey is reprinting the Carnegie Endowment translation of 1928. It says 1925 on the book, but it's actually 1928, within the next week or so. I have written extensive introductions to each of the 7 English translations over the last 7 or 8 years. And I have done so on the basis of archival research wherever that was possible. So I offer a different, we call it backstory, historical background of each of the translations concerned. The translations, particularly the one that's in press at the moment, are part of a series that all of you know called the Classics of International Law, that was financed and supported by the Carnegie Institution of Washington, which later transferred the project to the Carnegie Endowment, 2 separate foundations financed by the same individual. In 1906, James Brown Scott, who was a professor at Columbia and at the same time a solicitor for the Department of State, submitted a proposal to the Carnegie Foundation Institution recommending that they reprint with new translations, new introductions, illustrations where appropriate, and reproduce the original Latin text and a proper scientific English translation of what were considered to be the most important classics of international law. When I say he made the submission, you have no idea what physical form that submission took. It was magnificent. It was a printed, hand-printed on handmade paper pamphlet, which made the proposal to the trustees of the Carnegie Institution. I think it's quite a rare piece. I've seen only one copy. It's in the archives of Georgetown University in the holdings of George Finch. Now I've lost you on the image, but I'm not sure whether you're still listening to me or not.
Yeah, we are still listening. Yeah.
We're back. The trustees approved the proposal, and they then sent letters around to the leading international lawyers of the world, asking them for recommendations as to what book should be included in the series, and volunteers who were willing to produce a modern translation. And they got all of the positive answers you would expect, and they got offers to contribute translations in all of this. By way of a footnote, I should say that one of the individuals who was approached rather late in the project was Vladimir Hrabar, who learned of the series. There is a letter in the archives at Columbia University from his brother Igor, who was the distinguished art historian, but also a lawyer by training. And Igor wrote to James Brown Scott to offer the services of his brother as a translator of several volumes for the work concerned. The letter was in 1924. At the time, Igor Grubar had no way of knowing that the Carnegie Endowment had suspended the project because the translation of Hugo Grotius was so delayed that they were trying to punish the translator and embarrass him into speeding up his work. Igor Grubar said to Scott that Vladimir would consider emigrating from the Soviet Union and coming to New York to join the project if the Carnegie Foundation would support him in all of this. It's the only letter of its kind. Igor was in New York because there was a massive exposition of Soviet art, 1,800 pieces of paintings and engravings, etc. And there is an exhibition as we speak in Moscow at the moment at the Museum of Russian Impressionism that contains over 300 of those paintings, which were brought to New York at the time. Scott wrote back to Grubar and said he was sorry, but the project was suspended and this was not the right time to do it. So it never happened. But it's a small episode in Vladimir's life that we never knew before. And now we don't. Hugo Grotius's book on the law of war and peace was to be the center of the entire project. It was the one volume they wanted to do most enthusiastically. And they, for that volume and for all of most of the other Grotius volumes that have been translated, they chose not a lawyer, but either a clergyman or a classicist, a specialist in theology or in the Roman and Greek classics. And that was true of all 7 translations from 1654 until 1928. Interesting choice. That wasn't true of the other books. The other books were translated, you can see the list, by international lawyers, but not Grotius. They decided to do what we would call a translation by committee. Scott originally approached a priest at the Catholic University in Washington, D.C. to undertake the translation by himself. That man worked for 10 years. As far as we know, he never submitted any text. He passed away in 1916 of who knows what illness, but he was fairly young at the time. So Scott looked for a replacement. And he looked for 18 months to find somebody, and he found an individual that he believed was the ideal person, a man named Francis Kelsey. Kelsey was a professor at the University of Michigan. He was a distinguished classicist. He had a strong record of publication of translations of the classics. And he and Scott were both Presbyterians or Calvinists, if you will, as was Hugo Grotius. So Scott persuaded Kelsey to undertake the project. Kelsey said that he could do it if he were allowed to have a team of collaborators within 18 months. Now, you've looked at Grotius, I'm sure. The Latin text is 800 closely written pages. Grotius wrote it after his escape from prison, but he did not have much access to a library at the time. So he worked for a lot of his text from memory, which means some of his quotations are not as precise as they would have been if he had had the original text. Scott agreed to the committee approach, and Kelsey made it clear, and this is of signal importance to us, that he wanted the Grotius text in English to appear as though Grotius were an Englishman. In other words, he wanted the text to read in such a literary style that it would appear that Grotius was a natural and excellent English speaker and stylist, and that they would edit the text so that the translation reflected that approach. So Kelsey said, I have 3 colleagues in Michigan who are all working in the classics. They're either classicists or political scientists, and they will help me on this project, and we will divide up the Grotius book into subsections, and each of us will take a subsection, and I, Kelsey, will edit the entire product to your satisfaction. Scott agreed. They agreed a sum of money, which was not bad at all at the time, and the project got underway. Then, of course, certain things happened. The World War I ended earlier than they expected, 2 years earlier than they expected at the time. And they wanted Grotius available to the negotiators at Versailles because they thought it would be helpful to them. So they affected their deadline. Secondly, Scott was appointed to assist the peace delegation in Paris. So he was removed from Washington for an extended period of time, which meant he couldn't supervise the translation. Kelsey, in the meantime, was an archaeologist as well as a classicist. And the end of the war meant that he could return to the Middle East and complete some excavations that he had been involved in before the war, and he desperately wanted to do. So that also affected his ability to devote time to the translation. This and other factors contributed to a much slower product, and I won't dwell on the details here today, but the result was that instead of 18 months for the translation, it took 10 years to produce it. And the archives disclose a remarkable record of correspondence between Scott and Kelsey. Kelsey was a master procrastinator. He could delay anything, and he had every possible excuse for it, all in the interest of publishing the translation, of course. So they finally did it. They chose the Oxford University Press to be the printer, not the publisher, but the printer of the book. Publisher is the Carnegie Endowment itself. And the problems of moving the manuscript back and forth between Oxford and Washington and Ann Arbor were immense, but they succeeded in doing this rather well. They wanted to have the book published by 1925. That was the anniversary, 300th anniversary of the original first edition of Grotius and the Law of War and Peace. They didn't make it. Kelsey delayed and delayed and delayed. Kelsey died before the book finally was published, but he did approve the final proofs. The book was actually published in September of 1928, and the date on the title page is a fictitious date. It shows 1925 at the insistence of the Carnegie Endowment. Now, I dwell on this one in particular because as international lawyers, we often say we speak a common language, but we don't speak a common language. We speak a common terminology, and there's a big difference between the two. We all speak our respective national languages. As international lawyers, we all know some Latin phrases, jus gentium, pacta sunt servanda, rebus substantibus, etc. We work with Latin phrases, but I suspect that our fluency in Latin is not nearly good enough to read Grotius in the original. And the 7 translations that have been done of him in English, I'm asked frequently, are they any good? And my answer is they're all good. They all represent the considered reflections of either an expert classicist or a team of classicists, and they each present their own perspective on what they understand Hugo Grotius to have said at the time. And they differ with each other, of course, because they have different perceptions of what Grotius intended at the time. So to apply Olga's criteria here, the comparative study of classics, the translations of classics of international law, is entirely an appropriate exercise. Grotius, of course, was translated into Church Slavonic in Kyiv in 1712 by instruction of Peter the Great. And the manuscript, as I understand it, is located in St. Petersburg, although you may have a copy in Ukraine somewhere or other. I have been a strong proponent of your publishing that translation with a modern Ukrainian text to go with it. I hope someday you'll do it. It's worth doing it because it's part of the whole history of this exercise. And when I say history, I don't mean merely the history of the book. One of the things that translations is a history of is the movement of international legal concepts from one part of the planet to the other. And I've done some work on Pyotr Shafirov, as many of you are aware. One of the things we discovered of Shafirov's book of 1717 was that he uses terminology of international law, some of which dates back to the 10th century, and others of which is imported into the Russian language at the time from Polish, from Italian, from Latin, from the Dutch language, German, English, etc. When the language moves, when the words move, so does the concept move with it. That's the assumption. So Shafirov's book is a printed work. It's the first original printed work on international law in the Russian language. But that means that there are manuscript sources behind it which should reflect the same terminology. And they would represent first use of the relevant terminology concerned. So it means that we have something working in parallel with the development of national legal systems. We have a concept at work of international legal rules that societies, whatever stage of development they may be at, are developing and sharing with one another, and they're developing a common terminology in their respective national languages to incorporate these notions. So in other words, translation and the use of language becomes one of the tools by which we can trace the movement of international legal concepts from one to another. It doesn't necessarily mean compliance. That's a different study. Maybe they comply with the rule, maybe they violate the rule, maybe they reinterpret the rule, etc. That's all the proper subject of study by all of us who are interested in the history of international law. But the foundation for what we're doing is the use of the terminology itself. And I think that the translations that we have, whether they're modern or classical, are all offering insight of one kind or another into this particular process. Now, I decided not long ago, earlier this year, that I would undertake quite a different project. I would undertake a project of translating Fyodor Fyodorovich Martin's Современное международное право цивилизованных народов, the contemporary international law of civilized peoples. I had a big debate with myself about how to translate narod, whether as people or as nation. People have translated it in different ways. I think that on balance, if you read Martin's as a whole, he really is talking about peoples, and I chose that version. I'm aware that others may disagree with it. We'll engage in the dialogue when it's appropriate to do so. It's a work that was in its time translated in the first edition into French and into German, a later edition into Spanish. There is believed to have been a Persian edition. We think that's not true. We think that instead a Persian international lawyer who studied in Petersburg used either the Russian or the French translation and adapted it to his lectures in Persia on international law. And there's a very interesting article on that, documenting that in Euskentium of recent origin. There were two Japanese translations, 1900 and 1908, one of the 4th edition and one of the 5th edition of Martin's. My translation is of the 5th edition, 1904, 1905, but it does two things that none of the other translations do. First of all, it introduces into the text certain sections of the work which Martin's, for some reason, eliminated from his 2nd, 3rd, and 4th editions. I don't know why. He left the section number, but he left it blank and removed the material. I reintroduced it for the English translation so that the English reader will have the full text of whatever Martin's produced from beginning to end. Secondly, the footnotes. Most of you will have read Martin's probably in the Russian publications of either 1996 or of 2008, published by Zertzalo. These are seriously abridged translations, сокращенные, and they've eliminated for I'm sure reasons of space, a large amount of both the foreign examples which Martens gave in support of his arguments, and most of the literature which he cited that was not Russian literature. And it makes a difference to see the full Martens instead of the abridged Martens. I can understand for student purposes, teaching purposes, why you would abridge the text. It's 2 volumes and it's very large. You're talking well over 1,000 pages of material. But on the other hand, if you take this out of Martens, you are missing an essential part of his intellectual contribution to international legal doctrine, both for the Russian reader, the Ukrainian reader, or for the foreign reader. In fact, he had a tremendous command of foreign literature on the subject. And in the original Russian text, he used it to considerable advantage. Another feature of it is that he numbers his footnotes on every page from 1 to 2. So there's no consecutive footnoting in the book. Now you may consider that just to be a minor technical observation, but I consider it from the history of books to be quite important. It meant that he could update his editions of Martens without disturbing the sequence of footnotes. So he could add things, he could take them out, and he was imposing a minimal burden upon the publisher at the time. And his book went through 5 editions in 25 years. That's not bad. He updated it every time, he added to the literature. There were certain things that he was preoccupied with because of the conferences that he was involved in or the negotiations that he was involved in. He also worked in foreign archives and libraries. It's clear that that would be true. No Russian library could have supported the literature that he cited just on the basis of its own holdings. I don't think any single foreign library could have either. He used them around Europe at the time, and he traveled frequently there. I know he spent time in French archives for doing his treaty collection because we have separate evidence of that, and he found excellent documents. He was looking at the foreign European side of Russian diplomacy at the time, and he found references and sources, of course, that were not available in his own archives. On the other hand, he cites St. Petersburg archives, which nobody else had access to except him. And a lot of that material got edited out of the later reprintings of his work. So the idea is that for the first time, the English reader is introduced to Martens and his substantial contribution to international legal doctrine. We've never seen it before, unless we read German or French, or we were confined to the early editions of Martens. We've never seen the most mature version of his work. And now I hope we will. The first volume is in press as we speak. It's finished. I'm halfway through the second, and I hope to have that out in the early spring. That, I trust, will enable more comparative work to be done on doctrinal works of the era concerned. The 19th century is of greater interest to us these days because it seems to be more relevant to the international system we're living in at the moment. We've moved out of a Cold War period, which had a different dynamic than the one that we're experiencing. It's entirely natural, of course, that we look as best we can to the earlier period in world diplomacy, not because we expect to repeat it, but hopefully we may avoid some of the mistakes of the past and learn from some of the successes of the time. So let me close with the observation that we have translations of classics or non-classics, as the case may be, of contemporary works, which offer us, of course, new perspectives on what the author has to contribute to our subject. But they do more than that, because they represent the effort of the respective translators to move from one language into another, what we understand to be a more or less common terminology for a legal system that has its regional dimensions and its regional histories, but at its best, we hope will be universally acknowledged and recognized throughout the entire planet. Thank you very much. And may I offer my congratulations to the Ukrainian Society for arranging this occasion and for doing so in English. I'm impressed enormously by an audience that can handle a conference like this in a language which is not their own. Thank you very much.
Thank you very much, Professor Butler. Thank you very much, because here really Professor Butler is an eminent specialist in archives and in study of archives of international law and study of sources of international law. And here, what I have said about, we may add that maybe these terminological problems of translation, that is the separate field which should be covered by the history of international law and by the theory of the history of international law. Here we have another rather huge problem in the history of international law. And by the way, as it was said during our previous meetings in the Ukrainian Association of International Law, there is a need to develop the study of archives. Archives, I mean the study of scientific sources of scientific sources of international law. So thank you very much for your report, and thank you very much for this speech. And now I would like to present Professor Carty. Professor Carty is professor of Beijing Institute of Technology. Before that, he possessed a chair in Hong Kong University, and before that, he was professor in Aberdeen University. And Professor Carty is not only well-known specialist in the history of international law and theory of international law and sources of international law as well, but also he is an author of dozens of works in this field. So Professor Carty, the floor is yours, please.
Thank you very much. I think I'm no longer muted, right? I understood that one was to simply make some remarks for 10 or 15 minutes, and that then there would be an open discussion to the floor. But both the previous speakers have spoken for about half an hour and given full papers, but I will not be doing that. I'm simply going to make some controversial remarks about the debate about methodologies of history of international law, which I hope would not run for more than about 10 minutes. And I have written them down so that it's not too rambling what I have to say. So methodologies of history of international law. How does the question arise at the present time? It's certainly become a passionate issue for discussion, and I get sent on the Academia EDU nearly every day an article written about the history of international law. There is the volume edited by Craven and Margosha Fitzmaurice around 2004, 2007, I think, Time, History and International Law, and I participated in that along with Randall Leshafer. Now we have very recently Schaefer and Peters from Heidelberg have then published a volume which just arrived with me this morning, Politics and the History of International Law, The Quest for Knowledge and Justice. And then there is, Anne Orford has just published International Law and the Politics of History, which I have had an opportunity to look at, and but look closely at some aspects of it. But it's a 400-page study, and I have still to look at it very closely. Now, the study coming from Schaefer and Peters arises out of an explosive article in the Journal of the History of International Law, written by an American soldier, retired soldier, arguing that the Indian killing of white settlers in the Jameson raid in early American history was genocide. This provoked a ferocious response from Anne Orford, who resigned from the journal as an editor of the journal at this time. So there is, I'm assuming that there is huge explosive controversy around any issue to do with international relations. I'm also assuming, contrary to Olga's very careful presentation, that pretty well every significant international legal concept and rule is disputed. And there is no prospect of producing a history of any legal concept which is going to receive anything like unanimous reception. But partially the issue raised very meticulously by William that problems of translation, in my view, in international law are pretty insurmountable, and not merely within Europe, but especially between Europe and non-European civilizations. Now, the study, hoping to stimulate discussion or to say something relevant to our audience, I noticed that in the introduction to Schaefer and Peter's edited volume, that these two editors specifically mentioned Ukraine and Russia, saying that governments normally seek to harness academics to instrumentalize scholarships for their ends and to seal debates by decreeing an official history. And apparently there is a letter from scholars on the Ukraine, a so-called anti-communist law letter of April 2015, referring as well to Putin's legal and administrative distortion of history as being unjust. It is difficult and contentious issues should remain matters of debate. Now, the book goes on to argue, these books go on to argue that one has to find a way between these two editors go on to argue one has to find a way between the unattainable ideal of scholarly neutrality and the partisan politics on the other side. It is a matter of personal inclination whether one errs more on one side or the other. Well, I regard this dichotomy as meaningless, and there is no objective definition of what is partisan, and there is no objective basis for criticizing governments for attempting to amass legal arguments to support their case. That is what law is about. So this is very puristic, and I am very opposed to this whole way of posing the problem. Anne Orford devotes a major part of her very comprehensive and, of course, extremely intelligent book to challenging a philosopher and historian of ideas called Ian Hunter, an Australian. And she argues from a critical theory perspective, as does also Kotkaniemi, that every judgment will be a matter of political choice, and it is a mistake to try to resort to history to provide objective answers. Kotkaniemi tells Lorraine Benton, another historian of international law, that all history writing is a matter of selection of evidence. Now, my interpretation of this is that my view of this, based on my experience of international legal history writing, which I have intentionally and unintentionally spent most of my life doing, I have written a lot, is firstly that speaking generally of professionalism and scholarly neutrality and scholarly scientific aspirations, I follow the view of Alistair MacIntyre, the philosopher, that the Enlightenment objective of seeking scholarly neutrality and the Encyclopedia Britannica's concept of scientific and objective truth, based perhaps on archives in the light of the method that William adopts, is a false analogy drawn from the natural scientists. It is trapped at present, in Europe at least. Europe at present is trapped in a materialist, hedonistic, individualist view of reality, which means that modern scholars in Europe and North America do not accept any objective perspective can be provided on anything. Everything is a matter of opinion. And that is basically, some opinions may be more intelligently articulated, they may be based on some more materials than others, but they all come down to a matter of subjective choice. So there is, in my view, a nihilism underlying Western culture, which one really cannot combat very much directly against. More specifically and importantly, this approach assumes unconsciously, and I think this is where I'm becoming particularly provocative at, that no morally objective standards exist anyway, and that one has to and can enjoy remaining agnostic about any serious international conflict. especially one to do with conflicts among nations. And for this reason, international lawyers prefer to remain agnostic about most international issues, which is why I would make the very firm statement that I have made in a video recording with Jean d'Astremont, which is now available on the web page of the Manchester International Law Centre, that most history writing, most of the history of international law writing at the moment is of no interest for an understanding of present international conflicts. It's really a navel gazing of Europeans fascinated with themselves.
On YouTube as well. On YouTube available.
My own on YouTube available. It's on YouTube available. This lecture, this conversation I gave with Jean d'Astremont. Jean d'Astremont is a magnificent conversationalist, so he doesn't allow me to shout at him for an hour. We have a conversation. My own strong existentialist feeling, this is where I come from in terms of philosophy, existentialism of Sartre and Camus, is that these tendencies among privileged, socially advantaged Western Europeans and North American academics aim to remain outside conflicts and remain agnostic about their origins. Therefore, the mainstream avoids any discussion of major international issues, such as the legality of the State of Israel, and especially now the issues to do with China, China's century of humiliation, the conflicts over Hong Kong and Taiwan. I mean, at the present, the United States is trying to push Taiwan back into the United Nations. Israel may at any time attack any of its neighbors. And these are issues likely to lead to a Holocaust in international society, and yet they are completely off the table of discussions of the so-called history of international law. I'll take one immediate example facing the European Union at the moment. That concerns myself because I'm an existentialist in my approach. The Northern Ireland Protocol. I come from the north of Ireland a long time ago. The approach of the Belfast Agreement, or the so-called Good Friday Agreement, is typical of this agnostic approach to international conflict. The two sides disagree, so let's solve it somehow or other peacefully, but without getting to the foundation of what the quarrel is between them, because there is no way of finding an accurate foundation to any quarrel. I wrote a book called Was Ireland Conquered in 1996, which is an attempt to look at the history of the conflict from a legal point of view and to determine who's right and who's wrong. And this was boycotted by the academia, and indeed by my critical international law scholars seem to be worried about it was even a book written by a terrorist. And yet now there is forceful controversy over the failure to choose which side in Northern Ireland should have the customs union border imposed upon them, whether it should be the Catholic community in relation to the south of Ireland or the Protestant community in relation to the United Kingdom. So I would argue very much that running away from getting to the foundations of conflict, which suits the agnostic materialist Western European, North American mentality and dominates the study of the history of international law, is really quite useless. With China, there is the fierce dispute about the status of Hong Kong, and the European Parliament has pompously denounced China for its position on Hong Kong, but of course the European Parliament has no understanding of the history of the Hong Kong conflict and is absolutely not interested. Western academics are unwilling to confront the history of the Hong Kong story. They won't look at the Treaty of Nanjing. They won't look at anything to do with China's history of century of humiliation. When I have tried to raise it at a conference in the Heidelberg Institute of International Law, I was simply told to shut up and prevented from speaking. Nor does any Western legal commentator intervene to consider the claims of China to Taiwan. This so-called turn to history in international law is a narcissist, incestuous debate within the profession of international law, which reproduces the agnostic culture of Western Europe and North America. I have written, and William has very kindly published here in his journal, a history of how the Taiwan issue was treated at the San Francisco conference. But none of this is brought to the front in an issue which, according to John Mersheimer, is the most likely source of a possible Third World War. So finally, my own view is that there is the possibility of robust intellectual and rigorous scholarship with respect to the history of international law. I favor the views of Ian Hunter in his arguments with Anne Orford, and I very strongly recommend, as I think he's the most intelligent person working in this field, an article he has written called Global Justice and Regional Metaphysics on the critical history of the law of nature and nations. And he's written another wonderful article, but it's something that would be very difficult to find because of the title, about the dialectics of historiography of international law, an article written in the Journal of the History of Ideas. The difficulty for us as historians of international law is that doctrine of international law is an integral part of the history of ideas, which has its own logic and rigor, which lawyers do not normally have. It doesn't mean they can't acquire this knowledge, but they won't have had it as part of any of their education. To especially take the crucial issue of customary international law. I briefly observed in the decay of international law in 1986 that the concept of general custom, the concept of opinio juris of nations being shared to found a historical customary law of nations, has its origin in early 19th century German idealist philosophy. I noticed von Kaltenborn as the person who first formulated this concept in the 1840s. I also noticed that this could not survive the nihilism of late 19th century industrial materialist, imperialist, nationalist Germany, where Treitschke and Nietzsche put forward a nihilist rejection of idealism. And yet this language remains encrusted in the language of international law. The famous continental shelf case of 1969 is merely a repetition of this idealist German concept. Now, to my mind, Ian Hunter demonstrates the truth of this argument much better than I could do, because he's a historian of ideas, whereas I'm a mere scribbler of international law. Now, there's another aspect of international law. Apart from doctrine, there is so-called practice. I've written about doctrine and practice of international law as a false dichotomy in the Oxford Handbook of the History of International Law. As for the practice of states, academics now largely parse the case law of the International Court and other international tribunals in order to indicate what is the customary practice of states. But in my writings, I show that it is possible to study specifically legal practice of states through archives and to show just how far states are or are not observing whatever they consider to be international law. I show this in my work on Fitzmaurice and the United Kingdom Foreign Office, which was published by Kluwer. An article on the missing admiralty orders provides a background to the Corfu Channel case, which is published in the Law and Practice of International Courts. But especially the legal archives of France and the United Kingdom on the South China Sea, which I regard as the pinnacle of my work in this area, which William has very kindly supported and published in a magnificent production of his journal, the Journal of International Legal History, which is exquisitely produced by the Law Book Exchange. A PhD student of mine, Jishan Li, at the University of Aberdeen, did a study of the history of the seizure of Hong Kong by the British and the Treaty of Nanjing of 1842. But it has been impossible to find any journal that is prepared to publish this. And I believe that there are deep, traumatic, collective psychological blockages here. The Europeans and Americans are not understand, despite all the scribbling of international legal history, what on earth happened to China in the course of the 19th and early 20th century. And they contribute nothing at the present time to the increasing tension between Europe, America, and China, where you have the European Parliament denouncing China as committing genocide, and the United States subordinating everything, including the issue of climate change, to struggling against China and reasserting the hegemony of the United States. So I believe, as an existentialist, and I'm trying to be sympathetic, I know nothing about Ukraine, but I identify with Ukraine as a country that is beleaguered by a powerful neighbor. And I come from a country which has been beleaguered by a powerful neighbor. I would strongly ignore the recommendation of Schaeffer and and Peters and get stuck into the conflicts that mark your Ukrainian history. These are the most important questions that Ukrainian international lawyers could be studying. And the whole history of the Ukraine from the time that it was part of the Ottoman Empire, how it was taken over by the Tsars of Russia, and the attempt of the Ukraine to become
Professor Carty, guys, can you hear Professor? Yeah, so Professor, we are unable to hear you. So we have some technical issue. I think that Professor Carty will now try to join one more time. Yeah, so he's adding. So, Professor Carty, yes. So now
I'm
we
happy
can
to
hear you.
conclude in a couple of minutes. Yeah. I have already spoken a bit longer than even I intended to. Well, no, I've spoken for 15 minutes, which is half of the time taken by the two other speakers. I don't make any bones about that. They talked far too long. I'm not allowing enough discussion from the audience of more than 70 people. But I personally think that academics, firstly, I would say in conclusion two things. We do not, as academic international lawyers, have the primary training you need to be a historian of international law. You need skills in two disciplines. One, archival diplomatic history, which I think somebody like William certainly has, and has shown that in his fascinating presentation. The other is you need an expertise in the history of ideas. And I really feel that we should take somebody like Ian Hunter as our model, and not the scribblings of international lawyers playing with the history of ideas. The third point is that there is no way of getting away from the crisis of civilization that the West suffers from. There is no understanding of objective knowledge, nor any understanding of objective moral values, and we are thrown into an existential crisis there, which shows itself also in, I think, for us in Europe, the most absurd denunciations of the whole world coming out of the European Parliament. I think they have denounced Russia and China as barbarians, and the Americans are never tiring of well, the Biden government is never tiring of denouncing everybody for everything. So we have to plow our own canoe, and we have to face practical difficulties which concern ourselves individually. And that is what I try to do with my life and in my writings. So thank you very much for giving me this space to present my views.
Thank you very much.
I'm looking forward to questions.
I'm looking forward to questions and rebuttals and arguments.
Yes, we have some questions. And really what you have shown to us is the evidence that we should treat history as a means of settling present day, current problems, and current problems in current conflicts, current problems, all of they should be may be settled while counting on the history of international law. But sure, for that we shall change somehow the methodology of approaching to history, and maybe we should create a new methodology in this domain. You have mentioned such an agnosticism of Western European and American historians or international lawyers, and in this context it was rather interesting. You have mentioned Professor Koskin-Yemi, and in his last book of this year of 21-21, in his book on history of international law, actually on views on the history of international legal thought, that is in development, probably in development of the gentle civilizer, he called that history not as a history of views, not as a history of international law, but as a history of legal imagination. And that is the evidence of such agnostic maybe approach, and rather subjective approach. And also we have some questions here, and I see that I have question, but maybe we shall we have a question to Professor Carty, we have a question to myself, and I think that the question to everybody. So maybe we shall start with Professor Carty. Can you extend more on the history of Chinese-Taiwan issue and why European perception of this is not completely correct?
Well, in my view of the record is that Taiwan was part of China for many, many centuries and recognized as such. And then you had a war, the Chinese-Japanese had a war 1895, and Taiwan was annexed by Japan. At the end of the Second World War, there was a consensus with Chiang Kai-shek that Taiwan was certainly part of China, and Chiang Kai-shek, who was then the effective leader of China, was given Taiwan to administer. However, Chiang Kai-shek lost the Civil War, and he retired to Taiwan. And at that point, the Americans decided that for strategic reasons, it was desirable to prevent China from recovering Taiwan. So that is a history. It seems to me that, well, the San Francisco Treaty then was a treaty from which China was not allowed to attend. And John Foster Dulles, who controlled that conference, ensured that there would be no resolution of any of the territorial disputes that had arisen with respect to China, either Taiwan or the South China Sea Islands. Because his primary objective was to bring Japan into an American alliance by restoring Japanese statehood. So all of this is actually published by William in the Journal of International Legal History. So it seems to me that the history here is really very problematic, but none of it is discussed at the present time. What is presented at the present time is Chinese aggression towards Taiwan, which is a democracy. That is the discourse. And John Mersheimer has actually stated in a long discourse in the London School of Economics that this is a burning point for a Third World War, which is much more serious than the division of Europe during the Cold War, because the boundaries are much more fluid and the issues are much more unresearched. But you will not find in any of the heart-rending, anguishing reflections on the so-called correct method of international legal history any dealing with this issue. To my mind, legally, it's quite clear that records, a Filipino research assistant of mine rooted out this material from the foreign affairs documents of the U.S. foreign relations documents, that in 1950, the Joint Chiefs of Staff of the American Armed Forces sent an ultimatum to Truman that under no circumstances should Taiwan be restored to China. This background is basically what I mean by considering the issues are very alarming. Now, I'm not saying that there is, from a moral perspective, an absolutely clear argument that China should have Taiwan restored to it, but I think the international law analysis of this subject is hopeless. At the time, the American State Department legal advisor informed the John Foster Dulles that the San Francisco Peace Conference and the Peace Treaty were a violation of international law, because an international legal conflict that involved Russia, China, and the United States, as well as many other countries and Japan, could not be concluded as a matter of classical international law without the active participation of all the participants in the conflict. Whereas this San Francisco Peace Treaty was the result of the exclusion of enemies of the United States. But at the present time, all of this is simply presented as Chinese aggression and violence, and it has to be resisted by the legal democratic states. And to my mind, this is quite hopeless. Obviously, I don't personally deny for a moment that I am influenced in my perspective by the fact that I have been living for 11 to 12 years in the Far East, in Hong Kong and in mainland China. So that is my perspective. I'm not speaking as the Pope or as God Almighty. This is just my perspective, and I'm happy to have debate and discussion about it. But the agnostic community of international lawyers, the last thing they're going to discuss is any really important question. So when I wrote my book, I started my career with the decay of international law, by which I meant the decay of international lawyers.
And that you want to encourage the audience to go
deeper. So I'm encouraging the audience to come back and to intervene and say what they want. I mean, most of the participants are Ukrainian, so these issues are for you really existential. The situation of Ukraine is existential.
Yeah. Thank you very much. Thank you very much, Professor. I also had a question here as to the recommendation, to recommend some literature, some works concerning institutional approach to the history. Actually, my idea was that there is a lack of institutional sectoral approach to the history of international law, and for the first time, such an approach was used, but in a very, very moderate way in the Oxford textbook on the history of international law. It was published in 2012, but actually we can describe it rather as a history of concepts, as a history of ideas, but not as a history of such institutional sectoral approach. I propose some elements of institutional sectoral approach in my work. It was published in Professor Butler's journal, Jus Gentium, Journal of the History of International Law, and there I propose some approaches as to the need to study international rules and institutes in their institutional sectoral history, and think that such an approach will be developed in further works, in further books. So we also have a question, and that maybe I think that foremost that's for my colleagues, for my foreign colleagues, that's about a Ukrainian issue, and that is about Ukrainian legislature. What is your opinion about future of Ukraine in approximation and adaptation to the norms of international law? Maybe we can adapt the example of other states in our legislature. So it's up to you, Professor Butler, Professor Carty, please.
I totally understand the question.
Yeah, I'll say again that you can give the.
That's about approximation and adaptation of Ukrainian legislature. What can you suggest to Ukrainian legislature? Should it adopt the example of other states in approximation of this legislature to international legal standards?
Well, I would think that the international legal standards are entirely contested, and what the Ukrainian parliament should do is to vigorously develop what it thinks should be the ideal international legal standards, and then project them onto the international community, so that the Ukraine has an effective role in developing international law, which is, as I've said already, in every respect, highly contested.
I take a slightly different understanding of the question, and I suppose suggest to the Ukrainian legislator that, first of all, the legislator ensure that Ukraine's legislation is in conformity with its international treaty obligations. And secondly, I think Ukraine has to make a decision about whether it really wants to become part of the European Union or whether it does not. And as long as you are, I understand that you're in limbo to some extent because of the European Union's reluctance to take a decisive position on this. But nonetheless, it has serious implications for your legislation. If you decide that you ultimately want to come in, even notwithstanding the kind of Polish objections that we're experiencing at the moment, then you need to go much further than you have so far in harmonizing your legislation with the EU. If you decide that you prefer a different relationship, then that will affect your approach to your own legislation and the extent to which that you decide to harmonize or not, and the extent to which you take into account other relationships that Ukraine might form with other communities, including the United Kingdom, separately from the European Union. So there's a substantial agenda in front of you if you choose to recognize it. But I think that you probably can't yourselves be on the fence anymore about whether you think that European Union is worth pursuing or not. There are implications to that with your relations with Russia, etc. A cynical Russian view might simply be to say Ukraine would be desirable within the Union because that would fractionate the Union to some extent. That was in parts of the United Kingdom also a view that was expressed before Brexit occurred, that you expand European Union membership in order to dilute the possibilities of integration. Well, the events have gone in a different direction, but the point is still there, and Turkish candidacy and Ukrainian candidacy and other candidacies all are an expression of that balance that's going to have to be struck. So I guess in response to the question, I would say that it would be in the interest of Ukraine to perhaps address this issue more explicitly than you've been willing to do so far.
Thank you, Professor. Also, we have a question about Russian-Ukrainian conflict, and can it be compared to any other historical conflict, and what can we use when it comes to this situation? Would you compare it to any other historic international conflict and explain how we potentially might apply that experience by resolving the present issue? I think that today, first of all, as for me, we have a rather different situation than historical conflicts. That's why a lot of scholars speak about some hybrid wars, hybrid conflicts. And today's world is different. Today's world is really different, and it needs different approaches. But in this case, we may use the potential of the history of international law in order to understand the very international law, in order to understand international law itself and its possibilities and its abilities and its potential in settling such situations. So for me, it's not the case of comparing with this or that historical conflict, but the case is with treating international law itself. Maybe my colleagues have some other views on that. If yes, if not, we also have a question to Professor Carty. Dear Mr. Carty, what can you say about China policy about Tibet and how it can be estimated within the framework of international law?
Well, I think this is a good question, which will also allow me to come back and to make some more remarks about Taiwan. The history of Tibet, as I understand it, is that Tibet was a tributary vassal within the Chinese Empire. And the Chinese monarchical empire concept of vassalage was very, very looser and more, if you like, democratic or broader than the Chinese Communist Party understanding of Chinese territorial integrity. And so until the beginning of the 20th century, China, the Ming Qing dynasty left the Tibetans very much to do their own thing. But Britain then encouraged, with the collapse of the Qing Empire, they encouraged the establishment of an independent Tibet. And then after 1951, the Chinese Marxist and therefore European-oriented concept of statehood led to the integration of Tibet into an integral part of Chinese territory, which has led to a much closer incorporation of the people of Tibet into China. I think that one of the issues which international lawyers should try to reflect upon is the relationship of concepts of democracy, cultural diversity, and cultural independence, and how they are to be reconciled with the traditional concept, if at all, with the traditional concept of territorial integrity of a unitary state. And so there are huge unresolved problems there, and I'm very uncomfortable about them. You see, this is where I dispute really how useful thinking about international law can be. To look at it from the Chinese point of view, mainland Chinese point of view, and a major consideration is that the population of Tibet is about 4 million people, but Tibet makes up about 25% of the territory of China. If Tibet were to be independent of China, which the Dalai Lama and others would basically hope for, though I know it's more complicated than that, the country would immediately come under the influence of India. And if Tibet was in the hands of non-Chinese powers, then the plateau overlooking the whole of the Chinese territory would be in the hands of foreign powers. So from a strategic and military point of view, China can't possibly allow Tibet to become independent. So that is the nature of international society, is that it is one hell of a mess. And one has to try to accept and understand that. I would not for a moment say that China's attitude to this question is satisfactory. I mean, it is itself rigorously overprotective and over-control oriented in everything it does. I mean, that can be seen from its response to the coronavirus, that even though there are merely a few hundred people in China infected, they will not allow any foreigners like myself back into the country. So I have a personal gripe at the excessive security orientation of the Chinese regime. But in fact, the chief executive of Hong Kong, who could hardly be described as anti-Chinese, has protested at the extreme control-oriented attitude of China. So it's a horrible mess, and I believe because I'm not a nihilist, I believe our function as international lawyers, call ourselves international lawyers if we want to, is to try to understand the collective traumas that different nations are suffering in their relations with one another, and to try to unravel these traumas, which have some legal and institutional aspects, but are primarily collective psychological aspects to do with the concrete experience of nations, of one another in history. This is our function as mediating these conflicts. We don't have to take sides. We have enough to do in trying to understand the pathologies of the relations that people have with one another. China's attitude to Tibet is primarily, in my view, determined by the way the British Empire exploited the weakness of China and managed to separate Tibet from China between around 1900 and 1950. That is the dominating factor of China, and China's fear of India and India taking over Tibet. In my experience of China is that it does respect religious freedom. And there is no attempt on the part of the Chinese regime to stamp out Buddhist culture in Tibet. Buddhist culture is an integral part of Chinese culture. And Buddhist culture is an integral part of the thinking of the Chinese Communist Party at the moment. It is integrating its traditional Chinese cultural and religious values into the whole approach to the governance of China. So it's not a conflict. It's not a conflict about religion.
Harmony oriented, right?
It's harmony oriented. It's not a conflict about religion. And our function as outsiders, if we have a function, is to try to understand these complexities and not to simplify them down to issues of democracy and individual rights. Yeah.
Thank you.
Thank you.
Thank you for the opportunity. And the same applies with Taiwan. I'm not a fascist. I don't believe that Taiwanese should be forced against their wishes into a communist state in China. It's much more complex than that.
Of course.
Thank you. And now I have a question for Professor Butler. Thank you, Mr. Butler. You have talked about difficulties of translation of Grotius works. On the basis of your personal experience, what are the most difficult aspects of the translation of legal texts, and how do you recommend to deal with them?
Good question, and I'm almost thankful for it. The great challenge for translations is this. In this program, itself is an excellent exercise in translation. Are you able to hear me? Are you able to hear me, Roman?
Yes, now
Yeah. We can. All right. I was thanking you for the question. You do an outstanding job of teaching foreign languages in Central and Eastern Europe. It's quite remarkable. But an example to us all. The great challenge for the legal translator is that legal translation, in my opinion, should not be literary translation. And we differ from most other schools of translation in exactly that. As lawyers, we depend a great deal on precision of terminology, precision of punctuation, etc. We need a translation to be as close to the original as possible. And to the extent that the translator polishes or improves the original text, that translator is indulging in a distortion in a legal context. I've often said, and I will repeat here, that legal translation is the foundation of comparative law. It is the descriptive dimension of comparative law. And what you are being taught in your school of translation is essentially literary translation. So when you come to translate Ukrainian legal terms into English, you are choosing by instinct almost and by precept. You're choosing English legal terminology to express Ukrainian legal concepts. That is a comparative law exercise. That is an analytical exercise, however momentarily it may happen in your brain. You are not merely translating the Ukrainian terminology into English, you are equating it to an English equivalent that you consider to be the same. And as a translator, you're usually not qualified to do that, which means that your best defense is to fall back upon as close to a literal translation as you can. It won't read as well, it will read stilted, but it has the virtue of being closer to the original and a more accurate expression of what the legislation or the treaty or the document concerned actually was intended to convey. That's why I commented on the Grotius translation of Kelsey. They deliberately set out to do exactly the opposite. They set out to make him appear that he wrote as an Englishman. And they were quite categorical in expressing that as their objective. You can read it as a work of art in its own right, insofar as they succeeded in doing that. Whether you think they've accurately conveyed the original Latin is another matter. And that is always going to be the case with any translation. And this is why computers can't do it, not to a standard that's acceptable in the world of law.
Thank you very much. Thank you, Professor. That was really interesting question and answer, and it's really a matter of work of many lawyers. So I don't see any other questions here in the chat. Maybe somebody has any additions, any questions? I see no. So that's why we shall sum up, and I'm grateful to our keynote speakers, to our guests for such a profound reports and such profound speeches, and also I'm grateful to our audience for the interest and for all the questions. I think that today we just started to discuss the possibilities of the history of international law in the future, the possibilities to use the history not only as a theoretical field of international law, but as a practical mean of dealing with international problems, international conflicts, and dealing with settlement of international disputes as well. So would like to thank our keynote speakers once more, and please study history of international law, love history of international law, and keep on international law and international legal values. Thank you very much, and supposed to see you on our next briefings of the Ukrainian Association of International Law. Thank you.
So thank you very much, Olga, and I look forward to seeing you again and speaking with you in a workshop like this. Thank you for organizing it.
Indeed, I share that sentiment entirely.
Yeah.
And nice to see you again, Bill, after
And
so long.
yourself.